Resources and professional
Check, check, 1, 2. Testing, 1, 2, 3. Check, 1, 2. Test. Check, 1, 2. Test, 1, 2, 3. Check, 1, 2. Test.
This is New York City on August 20th, 2011. A full year of the New York City Police Department's data on stop, questions, and frisks has been graphed onto a map of the 5 boroughs, with different musical tones according to the This is New York City.
Because we have young cops, inexperienced cops, and maybe they are stopping some of the wrong people, innocent people. I would be interested to see the guys that claim that they're innocent, if they actually are.
Get a little bit settled. Good afternoon, everybody. Oh, thank you for that. So we are going to get started. I'll wait till folks take their seats. Let me start by introducing myself. My name is Melanca Clark. I'm Chief of Staff with the Department of Justice's Office of Community-Oriented Policing Services. We're one of the grant-making components within the Justice Department with the mission of advancing community policing. And we work on a host of issues that are crucial to the business of policing, including, of course, the topic for today. So I'm very pleased to be here. So let me just start by providing a few framing comments about what we're going to be addressing today. And we're going to use this panel to discuss the many opportunities and challenges that are presented by the use of new and emerging technologies in policing. These technologies are not only changing how police police, but how communities and police interact with each other and the relationships of trust that they have with each other. And this is playing out in a variety of ways. So the ability to collect, retain, and share information has certainly greatly expanded since 9/11, which has provided law enforcement with new and important tools in crime fighting. But it's also impacted privacy and other constitutional rights of the citizens that law enforcement agencies serve. Data collection and dissemination of law enforcement activities have a key role to play, of course, in transparency and accountability. But again, these activities can have unintended consequences if not fully thought through. And of course, as we all well know, the public's perception of law enforcement has been deeply impacted by the use of smartphone technology in the hands of citizens who have recorded overly aggressive policing practices, including, of course, the most recent video from this week of the SRO officer in South Carolina that many of us have seen. So today with me to talk about how technology, data collection, privacy, and the public perception of policing intersect, which could each of those things be a separate panel, but in any event, we've got 4 distinguished panelists to help us do this. And I am going to introduce them in the order that they will be speaking and the order in which they're seating. So I'll start with Professor Donald Tibbs, who is an associate professor at the Thomas L. Klein School of Law at Drexel University. His expertise focuses on the overlapping issues of race, law, civil rights, and criminal procedure. And he's the author of numerous publications, including, and I had a lot to choose from, but Who Killed Oscar Grant? A Legal Eulogy of the Cultural Logic of Black Hyperpolicing in the Post-Civil Rights Era. Next to him is Spencer Wolff, who's a filmmaker and the writer and director of a documentary called Stop, which focuses on the Floyd stop-and-frisk case out of New York, which we'll be hearing more about today. He is also a practicing attorney, a former teaching fellow at the Department of Film Studies at Yale University, member of the New York Bar. He holds a PhD in literature from Yale, a master's in law from the Sorbonne, a JD from Columbia Law School, bachelor's degree from Harvard. We hope for your sake you don't have to pay for all those degrees for yourself. That's a lot and incredibly impressive. Next to him is Commissioner Charles Ramsey, who is, as many folks know, is the Commissioner of the Philadelphia Police Department, a position he's held since 2008. He started his career as a cadet in the Chicago Police Department, rising eventually to the rank of Deputy Commissioner. From there, he was the Commissioner of the Metropolitan Police District in the District of Columbia, Police Department, excuse me. Commissioner Ramsey has served a number of illustrious posts, including President of the Major City Chiefs Association and co-chair of President Obama's Task Force on 21st Century Policing. And finally, last but not least, we have David Rudovsky, who's a founding partner of Carey's, might have pronounced that, okay, Rudovsky, Messing, and Feinberg. He's practiced in the civil rights and criminal defense field for over 40 years, including cases on police and governmental misconduct, prisoners' rights, First Amendment freedoms, and racial discrimination. It's a number of books on those topics. He's argued 2 significant cases in front of the Supreme Court on the very issues that we're discussing today. He is a senior fellow at the University of Pennsylvania School of Law, where he teaches a number of courses and is also a recipient of the MacArthur Foundation Fellowship, otherwise known as the Genius Award. So we are very pleased to have this group of folks with us. And with that, I'm going to turn it over to Professor Tibbs to start us off. Thank you.
So good afternoon, everyone.
Good afternoon.
As I set up my technology real quickly here, I want to thank Melanca for that wonderful introduction and for my invitation to be a part of this panel today. I'm deeply excited to be here, and I'm hoping that the information that I share with you all will be really helpful to you. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures. And no warrants shall issue but upon probable cause, specifically identifying the place to be searched and the persons and the items to be seized. That is the language of one of the most important constitutional amendments. It is the language of the Fourth Amendment. And the Fourth Amendment is important because it is the cornerstone of the protection of our privacy rights. It is also the amendment that is most often related to police and citizen investigations. And it is the amendment that sends the important message that the framers of our Constitution intended for people to have rights against the probable or possible abuse of power by the government. Now, the first half of the amendment, as I explained to my students, is really what is known as the reasonableness clause. And the reasonableness clause requires that the police must engage in any police investigation that they want to, just so long as they proceed reasonably. And if that reasonable procession involves a search or a seizure, then it must be done within the confines of the suspect's privacy. Now, I oftentimes ask my students, what is a search? What is a seizure? Does anyone really know? There are very simple definitions to both, at least as it pertains to the Fourth Amendment. A search is nothing more than an invasion into your privacy rights. It is an invasion into something that you intend to keep wholly and solely private to you, your secrets. A seizure is an invasion into your possessory rights. It is a taking of something that belongs to you, that you intend to belong to you and no one else. Mine, 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 not yours, not yours, not yours. And so when we talk about the cornerstone of the Fourth Amendment, and we're really considering whether or not there is an unreasonable search or an unreasonable seizure, the whole framing of the argument depends on what your expectation was. What was your expectation in your privacy, or what was your expectation in your possessory interests? Now, the determination for what constitutes an expectation as it pertains to your privacy or your possessory interests actually comes from a case in 1967 called Katz versus the United States. And ironically, it involves or rises around a question regarding a police investigation using technology. Let me frame the case for you a little bit. It's 1967. A guy by the name of Charles Katz walks into a public telephone booth in Los Angeles. Upon entering the phone booth, he closes the door behind him, picks up the receiver, and begins to make a telephone call. Now, as I often stop in my class at this moment and I explain to my students, many of you might not remember what a telephone booth actually looks like. And I could put up a picture of a telephone booth, but it would look really archaic. So I always explain it this way. It is that box that this guy by the name of Clark Kent would actually walk into and spin around a few times and emerge out as Superman. And one must actually sort of stop at that moment and say, well, gee, even Superman wanted to remain private as it pertained to his identity. Back to Mr. Katz. So Mr. Katz now picks up this telephone receiver and he makes a call. And he begins transmitting interstate wagering information against in violation of a federal statute. And he's basically placing bets between Miami and Boston. Now, acting on prior information that he might actually be there, the police engage in electronic surveillance to tape his telephone call. And they use an electronic listening device. And that device actually has a recording mechanism to it. And they listen to the conversation and they record the conversation, and the device is connected outside of the telephone booth. They take the conversation and the recording of it, and then they reduce it to a document, a transcribed document, and then they want to introduce it as evidence against him at trial. He walks into trial, or better yet, his lawyer does, and says, wait a minute, that telephone call was a private telephone call. And since it was a private telephone call, you cannot use this information against me because I actually had privacy rights. So I'm going to seek to suppress this evidence at trial at this particular time. And the trial court said, no, well, wait a minute, we're not going to suppress the evidence, and here's the reason why. You don't have an expectation of privacy in a telephone booth, and there was no physical entrance into that booth because the recording occurred from outside. And this made a lot of sense in 1967, because at that particular time, our expectations of privacy in the Fourth Amendment was centered around property notions, as in what places are actually protected: houses, apartments, hotel rooms, whatever the case may be. So flowing from that particular case, the Supreme Court said, well, wait a minute, I don't think that we want to think about this as just reducing it to a series of places as to whether or not there is an expectation of privacy. As a matter of fact, we should think more broadly about that, and that this expectation of privacy should be something that extends beyond just what you have in the context of a home. And so it did. It decided to suppress the evidence. It reversed the lower court's opinion. And in the reversing of that lower court opinion, it issued 3 rules that are very important. The first rule that comes out is that what a person knowingly exposes to the public, even in their own home or office, is not protected by the Fourth Amendment. That's known as the public access doctrine, and it's important to what I'm going to talk about a little bit later on. The second rule is, but what he or she seeks to keep private, even in an area normally accessible by the public, may be constitutionally protected. May be. So the question then turned on, what does it depend on? What does that may depend on? And it depends on a test that was delivered by Justice Harlan. And Justice Harlan said there's 2 notions for how we will decide whether or not an actual search has occurred or a violation of the Fourth Amendment has occurred. The first part of that test is what's called a subjective test. And the subjective test just simply says that a person must believe subjectively that they have an expectation of privacy. Now, unless you are Superman, which none of us are, you really can't tell what's going on inside of a person's head. So you don't know what they're actually believing subjectively. Someone could say, I did believe that, and you could say, no, I did. No, you didn't, and you'd never be able to prove them wrong. So the second part of that subjective analysis is that not only must they believe that they have an expectation of privacy, they must do something to outwardly manifest that expectation so that all of us can tell, looking from the outside in. And in the case of Clark Kent or Charles Katz, it is the shutting of the phone booth door. The second part of the test is that once you exhibit your expectation of privacy subjectively, that expectation must be one that society is prepared to recognize as reasonable or legitimate. And so flowing from that particular case, from the Katz case, really is an entire discussion about what constitutes privacy rights. And what we learned from Katz is that the Fourth Amendment does not protect places. There are no protection for places. There are only protections for your expectations of privacy. And thus the larger question going forward is always, how do technological changes impact how reasonable your expectation is? Now, the framers of our Constitution had no idea that one day we would have these things called computers. And that you could open these little devices that are super light and click on a button to access this thing called the internet. And that this thing called the internet would give you access to the entire world. They also had no idea that one day, flowing from these bulky computers, would come these little smaller computers, these things known as telephones. And that these little telephones will look very different from the telephone that Mr. Katz picked up. And not only are they telephones that you can pick up and make a call on, they're also smart. They're very smart. In fact, why not call them smartphones? You can do all types of things with these little phones. The same thing that you can do with these computers. You can store information, you can store documents, you can store photos, you can store recordings, you can receive a telephone call in the middle of your presentation. Thank you to my best friend, Alan. Right? But I could even take this phone and press a button and make it set an alarm for me without even touching it. Right? Talk to my friend Siri, who exists inside the phone, and I have no idea who Siri is. Nonetheless, one has to think about how these telephones and how computers and how other technological devices have been impacted by what our expectations of privacy are. Now, I could stop right now and say, everyone, please take out your telephone, unlock it, and give it to me, and let me rummage through it. Some of you would be terrified, right, by what I might find. Some of you might not care. The point of that sort of exercise would be to show you that there is this thing called an expectation of privacy, and it really does reside in your technological devices. So the way that the law evolves is through a process called stare decisis, which really means let the decision stand, and the cases before it will dictate how the cases afterwards will be decided. And so what has sort of been the evolution of law in the context of our privacy rights? Or better yet, better stated, what has been the evolution of technological changes as it pertains to Fourth Amendment privacy concerns? In 1971, the courts decided in U.S. versus White, using electronic surveillance and a third-party access, that there's no expectation of privacy in information that you make public to someone else. That if I tell you something and I say, please, whatever you do, never tell this to anyone else. Well, you know what's going to happen as soon as you say that, right? And so as you reveal that private information, that means that they actually can reveal the private information themselves, so you have zero expectations of privacy. Think about what that case means in the context of Facebook, Twitter, Instagram, MySpace. In another case called U.S. versus Cairo, the police used beeper technology to actually follow the information that was contained in a container. The court said you have no expectation of privacy in the usage of electronic devices because there's no privacy right in your location. If I am standing here, how can I expect that no one knows or should know that I am standing here? Think about what that might mean going forward as well. In U.S. versus Kylo in 2001, the police used infrared technology to look inside of someone's home. The court said, whoa, wait a minute, we have to draw a firm line at the entrance to a house. Bright line and a firm line. Coming forward into U.S. versus Jones in 2012 and Riley in 2014. Those two cases, Jones involves GPS tracking, Riley involves the search of a cell phone. So we have lots of technology, and they're involved in every aspect of our life. There are cameras everywhere. Right now, we might even be live video streaming this presentation. And where does that information go to, right? Who uses it, and why, and for how long? And how do issues of race, gender, class impact the gathering and the usage of that information? Well, my co-panelists are actually going to talk about each one of those questions. But I will simply conclude by saying, remember cats, and remember the test. Do you have an expectation of privacy, and is it one that society is prepared to deem as legitimate? Thank you.
Pass it over to Spencer.
So I have to set this up now. Let's see if it works. We might want to flick the video stream. Great. So I kind of came at policing in a digital age somewhat differently from an expectation of privacy. But I like what this means for policing and how we think about videotaping and we think about film in regards to that. I conceptualize filmmaking in the digital age in which we live as a way to show the stories, kind of the human stories that lie behind the data, but the clip I've chosen, or the kind of smashed together series of clips from the film, showed different components of data collection, of video making, and of interpretation of police work through the lens of video. And I think I'll let it play, and then I'll comment on my, my kind of schematic breakdown of what I've shown, and then make a couple comments about policing and video making. So let's see if this works. It is not working. Let's try again. This is New York City on August 20th, 2011. Okay, we're gonna have to stop because the video is cut in half and it's not showing. Is there anyone in tech that can kind of move the video down or up? Okay. Let's see if that will do it. Okay. Yes, we now have a glitch. It's appearing perfectly on that screen.
Right.
They can see it perfectly.
Which is useless to the audience.
It was really all about you guys, so. We're just gonna. We'll try our audience advice, which was just to restart and just see.
Right, so we saw this kind of split screen.
Yeah. So, move it down so it affects it. Sure. So just bear with us for this technical glitch about data and technology.
This is actually perfectly appropriate.
You want to keep talking for a minute?
Well, yeah, I mean, some of what I was going to say afterwards was about the kind of subjective interpretation of video and of data, and I guess this is a perfect example about how data can be distorted. I'm not sure what sort of conclusions we can draw there.
It's a reflective moment, one
Yeah.
might say.
Yeah, a meditative one. Maybe if we switch to the computer in the back, and then is there a second window open? There's this one. Full screen under. Right up there. Okay. Yeah, that actually is pretty good. Okay. Let's try it. There we go. This is New York City on August 20th, 2011. A full year of the New York City Police Department's data on stop, questions, and frisks has been graphed onto a map of the 5 boroughs, with different musical tones according to the race of the person stopped, and lower tones for arrests. After dark, the stops go haywire. Young men of color make up the majority of the stops, and for them, the practice amounts to an unspoken curfew on the streets of New York.
The concentration of stops among particular segments of the black male population is pretty shocking. We did an analysis based on 2006 data, and we showed that among 18 to 19-year-old African American males, the percentage of those males who were stopped is 93%. That's an outrageous number. So then we said, well, that's really high. So we made some assumptions that 10% of the population accounted for 25% of the stops, and everybody else was stopped one time or more. So when you play around with those numbers, you get a figure of 80%. So even allowing for a generous set of assumptions about repeat stops, 80% of the male population, 18 to 19 years of age, who are black, are stopped one or more times in a year. That's an outrageous number.
So there may be some friction there, because we have young cops, inexperienced cops, and maybe they are stopping some of the wrong people, innocent people. I would be interested to see the guys that claim that they're innocent if they actually are.
It was hard to make heads or tails out of all of this. It seemed like the people on both sides were living in different worlds. Like stop and frisk was merely the symptom of a deeper separateness. I even found this guy on YouTube posting grainy footage of stops from all over the city. The scale was unbelievable. 600,000 stops in 2010, almost 700,000 in 2011. That was nearly 2,000 stops a day. I grew up in this city, but I couldn't even remember the last time I had seen someone get stopped. Had I been totally blind? So in another data glitch, we should have seen a graph rising with the number of stops. I don't know. Yeah, it's totally blown out on screen. But there's kind of a moving graph that's really neat that appears. that I can't really reenact, but and so it shows the stops going from 2007 to 8 to 9 to 10, from a number of 600,000 to 700,000, and kind of declining down into the past. And the thinking behind the collection of clips and interpretations that you saw, and notably enough, I mean, you didn't see what's at the heart of a lot of the film, which is people recounting their actual experiences of being stopped, and also the trial, Floyd versus City of New York. For those of you who don't know, was an almost 7-year-long class action lawsuit against the City of New York surrounding or challenging the constitutionality of the practice of conducting stops in New York City, which the city lost in the first instance. Judge Shinlin decided that there had been 4th and 14th Amendment violations. It was appealed by the Bloomberg administration, and then after Mayor de Blasio was elected, he dropped the appeal. But what I wanted to show in this clip was, we have, in a certain sense, all the different elements of data collection. We have that graph at the beginning, which was done by a couple graphic artists at Al Jazeera, but using New York Police Department data, and trying to kind of bring alive the kind of bare data, because data, as we well know, in this era of mass data, doesn't tell us very much, or in a sense tells us so much that we lose sight of its meaning, and that's kind of the role of interpretation and analysis. But that's data collected by the police on what you could call the citizenry, or those they come in contact with. The converse is obviously this individual named NYC Resistance, who is, to this day, a sort of video vigilante who's anonymous to this day, who was going around New York with a camera in his briefcase for many years, filming police and public interactions. We have Professor Fagan from Columbia Law School, who brings forth his own analysis of the data, and then we have, this is not a very fair clip to Officer McAllister, who you see. In the sense that, he was one of the original proponents and architects of CompStat back in the day, but in this moment he represents kind of the hunch, kind of the feeling of the trained police officer who still relies on his days in the field to kind of know who's a suspect and who isn't, regardless of what data may tell him. I'm going to be brief, because I think this kind of offers us a schema of interrogation. I'm going to just say a couple words on the rise of cop watch and citizen videotaping, especially in New York City, which is a ecosystem I know well, but countrywide. And I find it a fascinating phenomenon at the same time that we have this ability to collect massive amounts of data and analyze them and hone kind of hone and improve police tactics, we have this rise of a perhaps empowered citizenry that is armed with video cameras that, to their mind, enables them to produce counter-narratives, counter-analyses, narratives of police interactions that perhaps don't meet the media representations that we commonly come across, and that perhaps bring personal and lived experiences into this kind of massive data. And I think I'll leave it there for now, and exit stage left.
Thank you, Spencer.
I don't know how you. All right. Well, first of all, good afternoon. It's really a pleasure to be here with you this afternoon. I was asked to address the topic of new and emerging technologies and the impact it's had on law enforcement. And so I want to spend just a couple minutes doing that. As Melanca mentioned during the introduction, I had the honor of serving as co-chair of the President's Task Force on 21st Century Policing. We addressed specifically 6 different areas. We called them pillars. Not thinking that we covered everything, but for the period of time that we had to get a report on the President's desk, it made sense to kind of focus in 6 key areas. One of those areas, which we call Pillar 3, was technology and social media. Now, I've gotten a little bit of feedback from people that have read the report, and one of the common things I hear is that we didn't spend enough time talking about body-worn cameras. Well, there was a reason for that. First of all, let me say I'm a proponent of police wearing body-worn cameras. That's not the issue. But today we're talking about body-worn cameras. Tomorrow we'll be talking about something else. Because technology is advancing so rapidly, what we didn't want to do was date the report before it was even published by focusing too much on something that may be current today, but probably would not really survive in terms of the main focus in the future. Because there are issues, not so much about the specific piece of technology, but other issues that we wanted to address. Technology is moving faster than policy and the law can keep pace with. So there are some very, very important questions that need to be answered and that in many cases are still unanswered. And I'll use body-worn cameras to start this off. There are questions about policies that departments need to have in place around when is it appropriate for an officer to record. Now, I'm going to set aside all those different wiretap laws around the country because they all vary as to what you can do, what you can't do, all that sort of thing. But let's presume that if you're wearing them, there's things that have already been worked out that you have the ability to be able to both video and audio record during the course of your duties. But when is it appropriate for an officer to turn the camera on? When it is appropriate and in what circumstances should an officer turn it off? How long should that footage be maintained in our custody? These are all very important issues that we need to be able to address. Now, one of the things that we mention in the report, and I believe very strongly, that these are policy issues that we should not be making these decisions in isolation. We should be sitting down with community, but more, and just as importantly with the ACLU and organizations like that, ABA, other organizations to kind of think these things through because they have a tremendous impact on our ability to do our job and also make sure that we're working within the guidelines or framework of the Constitution and we don't go too far. So let me give you another with body-worn cameras. Should an officer who has been called to a house to address an issue of domestic violence, that officer enters into the house, should that officer be allowed to film inside that house? Now, you can argue either way, and I'm not here to say something is right, something is wrong, just something to really think about. Do you really think we all have our own private space called our homes? Do we really want police or anyone else coming inside our homes under any circumstance filming? If we do, okay, then what should happen to that video? There are states right now where there are FOIA requests, Freedom of Information requests, where people just want to see the footage of what Officer A did during his tour of duty. Do you really want that to be late night entertainment for people with insomnia to sit there and watch what happened inside your home during a time of crisis? Will it have a chilling effect on people and make them reluctant to call the police when they need help because they don't want to be on camera? We have a hard enough time getting victims of domestic violence to call now. Imagine what it would be like if we have to record that particular situation. Should we be recording when we're talking to someone who's been sexually assaulted? Is that an appropriate time? What if the victim is a juvenile? Again, these are questions that we need to sit down and we need to carefully think about what's right, what's wrong in terms of how police should conduct themselves now that we have this technology available to us. Most agencies use license plate readers, technology where you got cameras mounted on the car, and as you go down the street, it scans license tags. It can tell you if somebody's on a terrorist watch list. It can tell you if the car's stolen, if a person that maybe has got a felony warrant or something like that. How long do you think it's going to be before, instead of scanning license tags, you got facial recognition software attached to those machines, and now we're scanning the faces of everyone that's walking down the street? I'm not saying it's right or wrong, but just because you can do something doesn't mean you should do it. And we need to have these discussions up front so that we're clear about what those limitations are in terms of what a police department ought to be able to do versus what, quite frankly, your privacy is being invaded more in the private sector than it is in policing, but we're not here to discuss that. But it is a difference when police have the ability to use certain kinds of technology. We need to have these discussions so we don't do anything to violate people's constitutional rights and then lose our ability to be able to leverage technology that could be very useful when it comes to fighting crime. So that's why we didn't want to focus just on body-worn cameras. I mean, drones, there's some discussion around drones, and you know, I saw something on television the other day where I think it was Walgreens, certainly Amazon is already experimenting with using drones for deliveries and all that sort of thing. But what about that technology in the hands of police? Now, there are some circumstances where I can envision something like that being useful. Active shooter scenario or something like that where you don't want to put anybody particularly in danger and you just kind of surveil the area and try to get a fix on what's going on because you can't see it from your particular vantage point. But then do we really want drones flying around seeing everything you're doing in your gated and fenced off backyard, for an example, that would not have been in plain view had we been at street level? Again, I'm not saying it's right or wrong, but what I'm saying is there's some very serious constitutional issues and legal issues that we need to talk about up front before it becomes a Supreme Court case. Our goal needs to be to stay out of the Supreme Court, not to be there, because of something that a police officer may have done, and then we wind up with a situation that could perhaps cause some problems and issues down the road for the department, and more importantly, actually cause a lot of angst to the people that we serve. So technology is important. There are some things going on now. You probably have heard the FBI talking about this whole issue of going dark. There's technology that's there now that's being used by some of the major carriers of smartphones, for an example. Apple being the main one now, but others will soon follow suit, where they're manufacturing phones now that have encryption to the point where even with a legal search warrant, even with a search warrant from a court, you cannot get inside that phone. You can't go into the hard drive of a computer, even though this is a person that may be trafficking child pornography, that may be engaged in terrorist activity, or any other kind of criminal behavior. And even if you serve the Apple or whatever company it may be with a warrant, they can't even penetrate it because it's being developed to a point where even they can't crack it. Now, I am all for encryption. I think we don't have enough encryption to protect our identities and so forth when it comes to what's out there in cyberspace as it pertains to us personally. But I do think that with a warrant, probable cause, and a court issued warrant, then we should be able to have access to that information. That's my belief. So these are real questions and real concerns. And I think that to be on extreme on either side is probably not where we want to be. But we need to have the discussion, and we need to have it up front, because it's here, and this technology, again, is emerging a lot faster than we can keep up with. So with that, I'm going to end my 2 cents here and turn it over to David Rudovsky.
It's great. Also great to be here, and wonderful framing of some really important issues that I hope you can then be dealing with your students, because they're going to be living in a world that is as much different as ours is from the phone booth. In 1967, I have the same experience with my students. I say, "What's a phone booth?" And they look at me blankly, and then drop the dime in the phone booth, right? That's the used to be 10 cents for a call when I grew up. And imagine what your students are going to be dealing with in 30 or 40 years in terms of technology, not only that government has, but private industry has, that we as persons have, whether it's drones or everything else. Hard to think, but the pace of development is so great. Everybody's right. The courts have a hard time keeping up with it. We've got a Fourth Amendment that was framed in 1789 or so, and again, nobody was even thinking, right, about all of these issues. So I want to pinpoint a couple more that people have talked about. And comment a little bit on what the commissioner has actually done very well in the Philadelphia Police Department. So just on the technology front, we mentioned a few things about how technology can butt up against privacy, and how do we deal with that kind of situation, whether it's a GPS device that the police can use and attach to your car and trail you, as a case came out of Washington, that Jones case, for 28 days. That was a case where this GPS device followed somebody's movements for 28 days, 24/7. Police developed 3,000 pages of data as to where this person had gone. And yet the government had a very interesting argument. They said that's not a violation of the Fourth Amendment, because everything we did, if we had enough police, we could have followed that person anyway. That was all out in the public sphere. We didn't go in his home. We didn't go in his car directly. We didn't go in his business. Everything we did, he exposed to the public. What's wrong with that? And ultimately, a very conservative Supreme Court unanimously said, and Justice Alito wrote a concurring opinion in the case, saying, with that kind of information, whether it's a GPS device that trails you for 28 days, whether it's a smartphone that has all your personal data, or a computer or any other mechanical gadget that you have, when the police can access that, they're accessing more than a discrete piece of information. They're accessing basically a mosaic of your life. Everything is revealed, right? Your political associations, your medical problems, your relationships, whatever it is. And so when you start thinking in those terms, we can understand why the courts are starting to build in some protections there. Think as well about the Snowden revelations, right? NSA, I mean, talk about data, right? So what was the NSA doing? Sweeping in for many, many years every email and every phone call made in the United States. Billions and billions and billions, right, of transactions, phone, email, electronic communications. Without a warrant, secret program, Snowden finally revealed it, and we've seen the results of that disclosure, and at least having a public debate now, and some amendments to that law, which allowed the NSA to engage in that kind of surveillance. Even there, the NSA had a plausible argument that what they did was either authorized by Congress or didn't violate the Fourth Amendment. And so far, no court has really addressed that issue in terms of the Fourth Amendment. Can the government seize every one of our phone calls? They say, well, we're just seizing it and we're kind of storing it. We're not accessing the actual contents of the email or the phone call unless we get a warrant. Well, how about the sweeping in, right, of all those discussions? If you think the government's doing that and you know the government's doing that, a fairly strong claim that that's going to chill, right, a lot of discussions that you might have for fear that the government can secure that without any kind of reason. Just even today, there's technology out there that is just emerging through the courts. You've probably heard about technology for cell site information. The government can now actually track where you are by signals that your cell phone sends to the cell towers. There's triangulation. They've gotten so good, they can narrow it down to a very specific area. You keep your cell phone on, the government has this technology, they can really trail you and find out where you are, what you're doing. Oftentimes, as Commissioner Ramsey would say, that's important. What if we have a suspect, right? And we have to trail that suspect. Questions become, can they do it? Do they need a judge to authorize it in the first place? All these issues are extremely important, and I think we're going to see them continue to develop. The second thing I want to talk about is the question of the use of data. I mean, it's not only that we've got technology that can be very invasive in terms of privacy rights and this conflict between privacy rights and effective law enforcement. There's something else going on. There's the ability now to collect, and it's government, it's private industry, and so on, to collect huge amounts of data. And sometimes that data collection can be very, very useful. So, for example, you've all heard of CompStat, police departments using data about crime and crime occurrences to map, literally on a real-time basis, where crime is occurring, what kind of pockets of crime do we have in different areas. We can now deploy officers in response to crime in particular areas, and obviously a very useful kind of tool for departments. You saw something on the stop-and-frisk case in New York, and what's interesting about that case, and we've got a similar case in Philadelphia, actually, that did not get litigated. We actually settled with the city of Philadelphia. We had the same issues of stop and frisk here as they had in New York, claims that many people were being stopped without reasonable suspicion, claims that the stops were in a racially biased manner, that many, many more minorities being stopped, and issues like that. The problem, of course, in most places, as even the head of the FBI has said recently on this whole debate about police use of force and deadly force, is that for the most part, we have no data or very poor data about when force is used, when people are stopped, when people are frisked. We have pretty good data when they're finally arrested and brought to court. We have that data, but we have a whole sub-level of policing that's never really been exposed and analyzed in a significant way. So, for example, it came as a huge surprise to people in New York, for example, that the police were stopping 700,000 people a year. It came somewhat of a surprise to us in Philadelphia when we looked at this 4 years ago and found that actually in Philadelphia more people were being stopped per population than even New York. In 2009, there were 260,000 people stopped in Philadelphia in stop and frisk. And then when we started to look at that data, and the police department here, to its credit, had created an electronic database which had all that data, as opposed to most places in this country. If you go to most cities or localities and ask the government there to disclose how many people have been stopped and frisked in the past year, in 90% of the jurisdictions in this country, they'll say we don't keep that information. If it winds up in arrest, we'll have a record of it, but for the 99 out of 100 that don't wind up in arrest, we have no record of it. We don't know who was stopped, we don't know why they were stopped, we don't know the circumstances under which they were stopped. Here we have that data, and so we can analyze it, and so we can look at a regular basis, both the department and those who are monitoring the department, we can look at that data and see whether or not a police tactic, and there's a lot of dispute over stop and frisk, and you take one position or the other, whether it's overused, whether it's underused, whether it actually impacts on crime, all that kind of debate, but you can't have that debate unless you know exactly what's going on. And so what do we find, for example, putting aside racial patterns and whether people were being stopped without good reason? One of the interesting things we found in examining stop and frisk, and you can only do this with complete data, is when we started to look at the number of people who were frisked and where police were saying, in effect, I have good grounds to think that person is armed and dangerous. That's the only reason they can frisk you, if they've got what we call reasonable suspicion that you're armed and dangerous. What we found, and what the department has found in our periodic reviews of frisks in Philadelphia, is that even though the police are saying, I frisked the person because I had reasonable suspicion that he had a weapon, because of a bulge or because of some kind of furtive movement. What we were finding, and regularly now for the past 4 years, just to give you an example, is that of all the frisks that are done, fewer than 0.5% wind up with a weapon being seized. That is 99 out of 100, 99 and a half out of 100 of people being stopped, those who were frisked, had no weapon. And it was almost kind of on a random basis. Indeed, the last time around we did another cut, we looked at all the cases in which an officer said, I frisked somebody because there was a large bulge, right, in his pocket, in his waistband, and his jacket. Out of 80 frisks that were made because of a large bulge, there were 79 cell phones and 1 gun, right? Now, you might say, well, that's still a good trade-off. We got that 1 gun off the street, right? You might say, on the other hand, well, this tactic is being misused, right? Doesn't matter where you come out, at least we have the data now, right, to inform that kind of debate, which is, I think, what the commissioner was saying. Without that kind of information, we can't even think about having the debate, and it brings me back to my, and I'll conclude with this, the same thing with the NSA, right? I mean, that stuff was kept secret by the government for many, many years. We didn't even know what kind of tactics they were using in terms of sweeping in our emails and our phone calls. At least we were able to have a debate after Snowden disclosed that. Whatever you think about what Snowden did, that's the only reason we were able to have that debate about privacy and law enforcement and terrorism. And does that program really help us? Has the government ever shown that a single seizure of any single phone call has ever led to an arrest of a terrorist, right? We can have that debate. We can't have it unless we have the data. The data is out there, and we have some transparency. And so I think all of us probably agree that none of these issues can be intelligently discussed, debated, or decided unless we've got this transparency, unless we've got the data, and unless we think ahead as to the impact between law enforcement and privacy rights.
Thank you. Great. Thanks, David. Terrific. So we have a few minutes to get into some questions with our panelists, and I thought I'd start to, as we've all heard, there are many different threads that have been picked up by the panelists in terms of the significance of data for transparency and accountability, the tension between law enforcement using these tools and privacy rights, other due process concerns. But also I think what's really interesting, because I would say, while the technology is new, the fact that there are these new emerging technologies, and Professor Tibbs pointed this out in the beginning, that's sort of an enduring and will continue to be an enduring dilemma because, as these technologies come online. But one of the things that seems unique about this moment in time is the fact that this technology is now, that there are new technologies that citizens are using that are having this impact on policing. So I think I'm going to start there with my first question being if anyone wants to comment on what they think the long-term impact is on citizens being able to tell what Spencer called these counter-narratives through the video recordings and the like. What do we think the implications of that are long-term on policing? Where do we think it's going to go? Take it from there if anyone wants to take that question. David, you want to start? You're pointing to Spencer. Well, Commissioner.
I think we're going to, find ourselves in a position of battling videos. I mean, cops will have video, people are filming, and so forth. I mean, when you look at the videos that you see now on television, these viral videos, they capture a part of what took place. And oftentimes it's not from the beginning to the end. And what I'm hopeful is that with the body-worn cameras, it will at least give you a more complete picture of what took place. Depending on what it is, I mean, it's either appropriate or it's not appropriate. But I mean, I think that that's why it's important that police have the ability to record. But I also think that if a person doesn't want to be recorded, that they ought to have the right to say, I don't want to be recorded. Now, I would strongly suggest that that be captured on tape, because later on it comes up, how come you didn't have the camera on? And it's because the person told me to turn it off, and you never know in these situations when things may not turn out right. But then would the officer then have the discretion, if they can see that this is a touchy situation, that they have the ability to maybe continue to record, even though that person may not want to be recorded. So these are complicated issues that need to at least be discussed, I think, so that we can come up with the right policy to be able to guide the actions of our officers. But the technology's here, it's not going away.
Right.
And so
sure.
we need to be able to adapt, adjust, and make sure that it's used appropriately when it comes to police using it.
Great, Professor Tibbs.
I think, well, I'm not, maybe.
Hello.
You can share.
Thank you. Commissioner Ramsey is absolutely correct as it pertains to the concerns regarding body-worn cameras and what types of things should be allowed to be recorded. I think maybe perhaps coming at it from a different angle is the concern over whether or not citizens actually have a right to record the police as they actually perform their duties. And so with the advent of cell phones and how quick and easy it is to press the record button, save that video, record what's happening in terms of policing, for example, a stop and frisk moment, and then take that information and download it onto the internet and to YouTube, raises a lot of sort of constitutional concerns. And this is nothing new. I mean, we as citizens have always had a constitutional right to be able to watch the police perform their duties in public. Also with that right comes the right to record them as they perform their duties, and the Supreme Court has been very clear on that. And what I think some of the concern may be sometimes is that what happens when police officers don't want to be recorded and their reaction to being recorded for snatching cell phones and things of that nature. Well, you have a right to record the police, but what you do not have a right to do is interfere with them while they're actually performing their duties. You cannot obstruct justice. And so it's important, I think, for citizens and for your students to know that if they want to actually record the police while they're performing their duties, that if they are told to move out of the way or to go to a safe space, they must do so. They have to do so. And that also is a decision that's come down from the Supreme Court. And that's not just for our safety, that's also for the police officer's safety. And that's the balance with the recording issues, is how do we allow the police to do the job that we want them to do at the same time that we exercise our right to sort of watch the performance of police duties in a public space without interfering with their ability to do their job.
Did you, Spencer? Yeah, go ahead.
Yeah, I want to say something about New York, which for me appears, at least to my mind, as something of a cautionary tale around data and its use. And one of the theories behind why these stops reach these kind of apexes, I mean, 700,000 a year, 2,000 a day, was this kind of relentless focus on the numbers, showed that it was a very easy and demonstrative way to show that the police were doing something, and that stops as a number that proliferates in a sense and shows activity every month. And the police, at least in New York, wanted to show activity to justify the numbers of officers on the street and so forth. And the kind of leitmotif of the discussions around all these numbers, around all this great activity, which seemed like a very positive sort of data set, was that these stops were an inconvenience, and Commissioner Kelly would talk about them as a daily inconvenience, a troublesome, irksome at time, but nothing more than that. And what started coming out with all these videos basically was they managed to show the nature of some of these interactions. I completely agree that they only show a piece of the puzzle, but they began to challenge that narrative that this is all good activity. And I think that's changed policing in a certain way, and these viral videos and these often incendiary videos that we see on YouTube every day now have catalyzed a discussion, much like I think the Snowden revelations, in a sense. I mean, it's making us question the types of activity that are permissible, and we'll see. I mean, the verdict's out about how all this video making will change activity.
David, did you?
Yeah, just one comment. I know the Commissioner here issued a directive a couple of years ago, making it very clear that officers should not seize cell phones and not interfere with people filming them, because we had a number of situations in Philadelphia where the police had actually seized it, smashed it, and so on. And he proactively did that. And but that's the year we're moving into, right? And maybe a good thing. I mean, some initial studies on body-worn cameras. Thank you. One of the first studies was done. One of the first studies was done in California, and a small town there that started to do the body-worn cameras. And what they found was, while the officers resisted at first, after a while the officers liked it, because when somebody came in and complained and said the officer did something wrong, they could pull up the video, and many times it showed the officer did nothing wrong. And as the chief of police finally concluded out there, when you're on camera, both sides act better, right? The officer acts better and the suspect acts better. And so probably, you've got all the issues about how we do it and how we store it and whether it's done in the house and whether we do it in domestic violence cases. We can probably solve all those problems, but actually I think in the long run, probably a good thing.
Yeah, it's nice to have that interest convergence possibility. So we started the discussion talking about, Professor Tibbs talked about the expectation of privacy, and I'm wondering, just thinking about our audience and who they're working with, given that young folks are literally living their lives on Facebook and Instagram, and I'm going to show my age because I don't know all the new things that people are living their lives on, but I know that that's happening. What has that done to the public's perception about our expectations of privacy, and then in turn the court's interpretation of those expectations?
So that actually the advent of Facebook has changed privacy rights considerably. There used to be a time, I remember, when we actually cared about keeping things really private. That we actually, things mattered because they occurred, not because we were able to share them with the rest of the world. And so what Facebook has done, at least particularly to this generation, is it has sent a message that if you can't prove it, it really didn't occur. And so therefore, there's a quick run always to Facebook to post everything that you might possibly be doing and saying. And the reality is that Facebook is a third-party communication. It is something that you share publicly, even if you share it with your friends. If you have your settings set to friends only and no one else can look in, the sharing of it with that friend becomes a third-party communication, and your expectation of privacy, as I explained for my students, goes from here to here. And the reality of that is that you have no idea what that third party will do with that information once you post it on Facebook. Share it with someone else, share it with friends that you don't want to be shared with. And so what the Supreme Court has essentially said is it has taken the decision in the White case, which said you can't have an expectation of privacy when you share it with the third party, and really sort of just transmuted that over to Facebook. And so it has changed policing also in some ways, because I can't for the life of me figure out why criminals actually post the videos of their criminal activity on Facebook. And so, or on YouTube, or on any of these public platforms to share with the world. And it has made policing, in some ways, it has made one aspect of policing, has changed one aspect of policing. One of the things that we've always known is that the police can't be everywhere at every time and at every moment. Well, when you put it on Facebook, and when you put it on YouTube, you have actually sort of made that part of policing a little bit easier. And so it is now public record because it's shared with the rest of the world. Your expectation of privacy is extremely low. And so it's kind of easy to troll the online websites, YouTube and Facebook, and find evidence of criminal activity. Sure. And once it's exposed to the police, that actually is enough probable cause to secure a warrant to come out and conduct a search, or to come out and conduct an arrest. And actually can be used against you at trial as an admission by a party opponent. And so one of the ways that we've actually seen this in a great in a great deal of manner has actually been something that I work with, which is hip hop. And students or people who sort of go online and rap about their criminal activity. And then have that hip hop video used against them at trial. And there's a lot of obvious concerns, evidentiary concerns that arise out of that, but it all begins at this place of exposing it to the public.
Yeah. Commissioner Ramsey, I don't know if you wanted to comment on that or.
Thank God for stupid criminals.
I say that all the time.
So I'm wondering, I want to make sure we've got time for questions from the audience. Does anyone have anything that they'd like to ask? Sure.
I was just wondering if the panel could offer their remarks. A couple days ago, the FBI director made a statement regarding the Ferguson effect, that we've seen an increase potentially in violent crime due to criminals being emboldened or maybe police being a little bit hesitant with the proliferation of YouTube videos and cameras. So if you could just comment on the potential of a Ferguson effect.
Well, I mean, I was present in Chicago at the International Association of Chiefs of Police meeting, and I listened to his remarks. He had spoken to us a couple days before at the Major City Chiefs and said some things very similar. And he's the first to acknowledge no one knows for sure exactly what might be taking place, if anything. But it does seem that something is going on. Now, I'm not prepared to go so far as to say that police officers are just not doing their job, because I don't believe that's the case. It certainly hasn't been. I haven't seen it here in Philadelphia. I mean, when you look at the officer that was murdered in New York just last week, I mean, he's clearly chasing down a suspect that at the time he thought was just on a stolen bicycle, so it didn't slow him down at all either. But I can't say with 100% certainty, with 800,000 police roughly in the United States, that it has not had an impact on some. No one wants to be seen on a video, obviously, but I think we have to be careful not to overblow it. I also think that there's a possibility some criminals feel a little emboldened because, I mean, if they think police are more reluctant to be proactive, then perhaps they're more inclined to carry a gun or whatever. I don't know that for sure. I think the third part of this that's probably the most important when we look at crime, the way we measure crime, which I don't think is the right way to measure it, but we do, and that's year to year. And we're at historically low numbers in many cities. And so you have spikes, you have periods of time when you're down, periods of time when you're up, because you're comparing against the year before. And I know in Philadelphia, we're at the lowest level last year since 1967. So you're only going to get down so far. So when you look at a spike, it's too soon to say whether or not that's a trend, whether or not that's something we need to be. We're always concerned when we see a spike. But trying to get at what's the root cause, I honestly don't think anybody knows one way or the other. All those things are possible, but I don't think there's any data that would really show without question that that's exactly what's going on, this so-called Ferguson effect.
David?
Yeah, I was somewhat surprised at the director's comments, quite frankly. He gave a fairly nuanced talk about 6 months ago about race and crime, where I really think he hit some good points on the impact of race, community relations, and so on. And then to kind of speculate, right, with no evidence whatsoever, right, that the Ferguson effect, that police officers are somehow holding back, and holding back because they're afraid that if they intervene and they intervene wrongly, it's going to be on a video. Well, that's a good thing, right? I think officers ought to be thinking, right? Like that sheriff in the schoolroom the other day, right? If I do that, that ought to be up on video. And we ought not to be discouraging people from doing that on the theory that officers won't intervene properly in other situations. I mean, we don't give that pass to any other professional, right? Lawyers don't get a pass by saying, well, 100 cases I do it right, one case I'm going to do it wrong, right? Or a medical person. We shouldn't allow police to do that either. So I think that's a difficult thing to say without some very, very good data as to that police are holding back, and at least not to say that they're holding back for the wrong reason, right? They're holding back because they're afraid that if they act wrongly, it's going to be out there. So, But it's a volatile time. I mean, it's a very volatile time, I think, in policing. The race issue has now, become fairly prominent. We've got a lot of conflicts over those issues, and we'll see how it plays out.
Comments? Other questions from the audience? Go ahead.
I was wondering, speaking on, especially again, focusing on students, right? Because we have to and talk about.
Here, can I give you the mic? Oh, we just want to record it on camera, audio.
I guess just advice for us to give our students as to what are their rights in the classroom with regarding their digital technology.
Well, I mean, I'm not a lawyer, but let me just give it from a police perspective. If you find yourself in a situation where you've been stopped by police or whatever, cooperate. If you want to complain, do it later. If you want to, whatever actions you want to take, that's fine. Don't resist. Don't get into all that stuff right there. There are avenues that you can take, either internal to a police or outside with different organizations or attorneys or what have you. Don't get caught up in anything like that. Certainly they have a right to record. That is not a problem. They don't have a right to interfere. It's always debatable as to what point in time interference takes place and all that sort of thing. But, do what you're asked to do. And then there are ways in which you can deal with it later on. I don't want anybody getting put in a position where they wind up, in something that's not going to have a good outcome. That's my personal opinion.
Professor.
Yes, I think if you ask the three lawyers on the stage, we'll probably all give you a different response. But we do something at Drexel called the Marshall Brennan Program. And what the Marshall Brennan Program is designed to do is to send our law students into the high school to instruct the students on their First Amendment and Fourth Amendment rights, because that's usually what comes up the most in the high school context. And oftentimes I get an opportunity to go in and sort of help clean up some of the mess that even some of my students makes, trying to make sense of how complicated the law is constitutionally as written. And one of the things that I'm often reminded of, at least out of the students' mouths or out of the mouths of babes, right? They say, well, wait a minute, I understand what the law says, but that's not how it occurs, right? That there is a difference between the law as written and the law in practice. And so with talking to students, I think you should teach them the law as written, to talk to them about what their constitutional rights are in a written context, and then try to figure out how to manage some of the differences and ways in which it might be practiced. I think that there certainly is something to be said about making sure that they are always safe, making sure that they understand what their constitutional rights are. But the problem sometimes with children, which is very different from adults, which is what makes them children, is that they're very impulsive. And they respond to things in very impulsive ways and sometimes very deeply emotional ways. And that impulsiveness or that emotional aspect might be interpreted in the wrong way. Well, in a safe situation, it's okay, but in an unsafe situation, it's not okay. So those are a lot of the things that I think are issues that you have to sort of sit back as an instructor or as a teacher and think about navigating, because they create a variety of different fault lines for students to fall into. The most important thing that they should never do is resist. And the most important thing they should never do is interfere. The young lady, for example, that when the student got flipped over in the desk in South Carolina, there was one young lady that said, I was arrested too simply because I started praying. I got down and started praying for what was happening in that moment, and the officer interpreted that as interfering with his duties. Now, we can argue whether or not that was actually the case, but that is something that is always going to be a fault line, I think, for you as instructors to try to think about how to talk to students. But they do have First Amendment rights in the high school context or in a school context, and they have Fourth Amendment rights in the school context. And the case that really will help you teach about the Fourth Amendment in school is New Jersey versus TLO. That is the landmark Supreme Court case on Fourth Amendment rights in the school context. And it actually has a lot to do with not the police, but in fact a school administrator, who is in that case the police, right, but not a police officer, who conducts a search without a
warrant or probable cause. So that's a really great case to read and think about teaching your students.
So I think we have time for one more question.
With the 21st Century Policing, the President Obama's task force, what are the next steps with that as it relates to like social media and technology and things like that, or is there anything that's being implemented at this point?
Well, I mean, I've certainly participated in a lot of dialogue around the country with police chiefs on things that they can do to implement the recommendations contained in the report. I think it was yesterday or day before yesterday, the COPS office published a report, a kind of an implementation guide for law enforcement to help them through implementation of recommendations presented in the task force report. So there's an awful lot of work being done. After my retirement, I plan to continue to go around and actually help agencies move forward in that direction. I think I think it's a framework for them to use to improve their operations on a variety of fronts. And so we'll be working very aggressively. I certainly will be a part of that to see to it that these recommendations get implemented to the extent that they can be.
Thanks, Commissioner. And I'd only add the COPS office actually provided administrative support for the task force. And so I would refer you to our website where we're keeping track of implementation efforts, including what the federal, what the administration is doing to help support implementation efforts at the local level in certainly technology and social media, but across all the pillars that the Commissioner talked about earlier. And you can find the implementation guide there. You can find a blog. We've got a map that features kind of new things that are happening around the country. So with that, I would like to say thank you to our esteemed panelists. I think we have a lot of great food for thought for the breakout sessions that I know that are following this session. So thank you all.